guess so, eh? All right, so my name is William Ray. I'm a board member of, and for the purposes of our judicial review against Dr. Strang, the litigation agent for the Citizens Alliance of Nova Scotia. As you can see, I am a veteran of the Canadian Armed Forces. What? You want me to? Really?
There you
go.
That's better.
So as you can see, I'm a veteran of the Canadian Armed Forces, as was my father. My father, Lawrence Ray, and my uncle, William Ray, the man for whom I'm named, started riding their horses down from Roxford Bridge, Alberta, on the 27th of October, 1939. Upon reaching Edmonton, they sold the horses and joined the Canadian Expeditionary Forces. My uncle, being the smarter of the two, he fought for the Royal Canadian Air Force during the war, helped win the Battle of Britain, and then 80 years ago, this coming June, he helped provide air cover for my father and thousands of other young Canadians when they powered up their boats and began their final runs into the beaches of Normandy. What I know of that day, I learned at my father's knee. And, you know, for a surety, those young men were terrified. They were shaking. Men cried openly. But when their crappy little boats ground up on the rocks and those ramps went down, they stood up and they went forward like lions, because they knew for a surety that the freedom of the world and the future of their children depended on it. It obviously does again. And you and me are all in the boat together this time, and the enemy is within our gates. The weapons for this war will be different, and today I intend to introduce you to one of them, the rule of law. So, the rule of law in what are called common law countries, so that would be America, Britain, Australia, this kind of thing. The rule of law in common law countries is based greatly on a document called the Magna Carta, signed in the 11th century by King John. It is worthy to note that King John signed this document with the swords of his noblemen drawn around him. And had he not signed, the basic agreement was simply that even the sovereign must only rule through law, and that if the state or the sovereign does not, that if the state or the sovereign only rules through law, that we will offer no violence toward the state or sovereign. I will leave it to you to decide if that bargain is still in effect. There are two clauses of the Magna Carta that are still in effect, so I'll start with those. Clause 39. No free man is to be arrested or imprisoned or dispossessed or outlawed or exiled or in any other way ruined, nor will we go against him or send against him except by the lawful judgment of his peers and the law of the land. Section 40. To none will we sell, deny, or delay right or justice. That is the basis of our law. So in the modern context, it's not just the basis of our law, really. It's also a fundamental facet of the proper functioning of a democratic society. Because if power can act with no checks, we don't live in a democracy, obviously. So, in Nova Scotia, the rules for this particular game are held in the Nova Scotia Rules of Procedure. There is, and we'll have it on our website if it isn't on a handout, there is online a fully searchable version of the Procedure Rules of Nova Scotia. They outline, so basically what you have is you have the legislation, the laws, and the civil rules of procedure just describe how you can function in the court, what you must do, this sort of thing. The Nova Scotia Rules of Procedure give you three types of civil judicial proceedings. Those three types are application, action, and judicial review. So we'll start with application. An application is a request of the court to make an order for the remedy or relief requested. Now, an application is an original, this isn't, many times motions for injunctions are within a larger judicial proceeding. But an application is an originating document for a proceeding. So a good example of an injunction an application would be Robert Strang's ex parte application for an injunction against Everybody Drawing Breath in Nova Scotia, which he took out and was defeated down the road by the CCLA. The next type is an action. An action, a civil law proceeding often referred to as a lawsuit. This is what we would mostly be familiar with, a party going against another person for damages or for some other thing. And finally, judicial review, which we have been involved in against Robert Strang et al. Since October 2021. Yeah, perfect. All right, so judicial review, there are two main types of judicial review. The first type of judicial review involves the actions of the executive branch of government. So when we take Robert Strang to court, every administrator, every bureaucrat is considered to be part of the executive branch, right? They act. They are not elected, they act. So we are having the executive's branch's decision to issue the vaccine mandate reviewed by a judge. The other type of judicial review involves the actions of the legislative branch itself. This is where your constitutional challenge comes in. So the Bill 40 or whatever it is that's creating this digital ID. When they fully run that through the legislature, it is then open to review itself, right? The legislation, what you would do is you would apply and you say that this legislation is outside the Constitution. It is not allowed by the Constitution, or certain parts of it are prohibited by the Constitution. All right, so going back to application quickly. So one of the things you can apply for, and one of the most common things, is an application for injunction. So an injunction is a court, and this is what Robert Strang got against all of you. A court order restraining a party from doing some act is called a prohibitory injunction. So you're doing something to me, I don't like that, I go to court, a judge issues an order for it to stop. The other type of injunction is requiring someone to do something, right? So you can say that a government official should have done a thing and failed to do the thing and ask the court to direct them to do that thing. Kind of a good example at the moment would be the fact that sudden, what do they call it, unexplained death or unaccounted for death has gone through the roof, right? Now, one could say that given his position, Robert Strang has a duty to investigate why that's happening, a thing he should do. So you could theoretically go into a court and ask a judge to order him to do it. Does that all make sense? Yeah? Okay, cool. All right, so the test for an injunction. One, the merits of your case. So it doesn't mean the judge has to decide you're right, but you must have prima facie merit to your case. What you're saying must make some kind of sense. It must relate to the law, right? So just basically you can't throw in, I don't know if anybody's too familiar with some of the stuff Rocco Galati has done. Anybody? Okay, so this guy tends to put in these huge filings, but they don't hold together logically. And so he got thrown out on one of those filings in BC. The judge literally threw it back in his face and said, there's nothing I can do with this. So that's all it's meant by merit, is the thing has to have a logical structure, it has to engage the law in a reasonable way, and it has to be what they call a justiciable issue, which simply means it is something within the purview of the court to decide. Number two, irreparable harm. So the idea there is that if the judge does not grant you this thing that you wish, that you will suffer harm that cannot be made up, right? No amount of money, no amount of anything will make up for the harm that is done to you. Having an mRNA vaccine injected would be a good example of that. There is no amount of money or anything else that can change the fact that you had that injected. Balance of convenience is a bit of a weird one. It basically, the judge has to decide that on balance, granting you what you're asking for will cause, that there will be less harm caused to the person you're going against than will be caused to you if the injunction is not granted. They call it balance of convenience. All right, so we have next. Okay, so this is an injunction that we recently actually filed. I don't know how many of you aware, but the nurses and people that fall within that, back February 21st, these people have been off work for 2-3 years. February 21st, they were sent a letter that told them that if they did not reply, or if they did not let the Nova Scotia Health Authority, which private corporation, by the way, if they did not let them know their intentions by the 15th of March, 15th of March, that they would consider them to have resigned their position. So what we did is we went into court on behalf of an individual who was asked that we redact their name. We went into court on behalf of this individual, and we filed an ex parte application for an injunction against Nova Scotia Health. We filed an ex parte. Now, ex parte just means that your opponent doesn't get any notification of what you're doing. They're not aware of it. It's you and the judge, and that's it. This is quite common in applications made by policemen, right? Obviously, if the police want to tap my phone, they're not going to send me a summons so I can come and argue with them and the judge about tapping my phone. Kind of makes sense. So we filed as an ex parte injunction. We could do that because we only had 2 or 3 days between the time we filed and the deadline that they had set. And one of the things that allows you to file ex parte is that you do not have time to notify the other party, right? We said, well, we only got 2 days. We don't have the 10-day notification response period outlined. So we applied, the application was accepted by the Halifax court. The judge decided that they would not hear it ex parte and that we must give notice to the Nova Scotia Health Authority Corporation. But what they didn't do was change the hearing date. So we sent notice of this application to the Nova Scotia Health Authority at about 3 o'clock in the afternoon. Hi guys, here you are, see you at 9 a.m. tomorrow morning. So they walked in, and so this is the interesting thing. This injunction will never be heard by a judge. Never. And we still won. Because Nova Scotia Health Authority, given our argument here, basically was this, that resignation is described very tightly in the collective agreement that this person worked under. And to resign is you quit. You send them, you write them a thing, says, I'm out of here, I don't like you. And if you don't pull that back within 10 days, you have resigned. The only other thing covered in the collective agreement was if you don't show up and you don't call anybody and give them a reason, you basically just don't show up for work for 10 shifts in a row, they may consider that you have resigned your position. right? You obviously just left town. But there is no provision in the collective agreement in any statute regulation of Nova Scotia that would allow them to sua sponte or of their own accord resign her. Them. And so at 9 a.m. in the morning, Nova Scotia Health Authority sent their high-priced lawyers in there and ran the white flag up. This individual has returned to work in their own time and on the terms that they desired. And no judge ever heard this, right? And I would go with what Ms. Ibrahim said. Our legislative and administrative groups have gotten quite used to just doing what they want and facing no pushback. Because the truth is that for a citizen to take the government to court, you're looking at 100 grand. Most lawyers, you're looking 5, 10 grand before they'll talk to you, right? So our proposition here is that citizens can do this on their own, and we did. We beat, I don't know who it was, Pattison Law, one of the big Tony law firms, and they just walked in and put their hands up. Because the rules is the rules. And if you know the rules, you can beat them, right? Okay, so I'll move on to the next one is I'm not done yet. Okay. So in an action, which is more of a traditional lawsuit, the thing that underlies that is called a cause of action. So your cause of action is simply what is being done to you. What is it that is causing you damage? What is it that you need changed? So basically what we're saying here is that we believe that any group of engaged citizens has the ability within themselves to use the law. The laws, your rights, are not embedded in you and counsel. They are embedded in you. The law is for you. It is not for you and a $500 an hour lawyer. We have just over time allowed the system to be turned into this. And I agree that the language of the law and legislation is at sometimes quite opaque. Sometimes they just make up words. They just make them the fuck up. They do. I'm telling you. They wanted, the government came after us in our judicial review. They have asked what is called costs. Right? So this is something to take note of. So you go into civil court, you pay what you pay, whatever your filing fee is. Now the administrative law, like judicial review, is embedded in the civil procedure. The civil procedure provides for costs as a way to protect people from the legal system being used against them in a vexatious fashion. I.e., I don't like to cut a terrorist jib there, so I just want to mess with her, so I just start suing her, right? And I could do this. She's got to go buy a lawyer. She got to waste time. So costs are a way for the courts to prevent that kind of thing from happening, right? Because a judge can say, well, this is crap. So you get to pay for the day you're standing in court, which runs at about 10 grand for a full day, and you get to pay the other guy's legal fees in full. That is possible, right? Now there is a procedure right off the bat to ask for what is called costs immunity. And there is a lot of precedent in Canada for getting cost immunity on cases of administrative law, right? So, but you should be aware that yes, there can be, even if you don't lose, there can be financial costs. And this is why what we do and what we recommend So we are in court against Robert Strang, but I am the litigation agent, so I'm the guy who gets up and yaps my face off in there. But I'm not in court against him, she ain't in court against him, and she ain't in court against him. The corporate human being, Citizens Alliance Nova Scotia, is. So if any costs are awarded, they are awarded against the corporation, which could suddenly become bankrupt, who knows. So this is how you as a citizen, and forming a nonprofit, I think you can do it for as little as a couple $100, or go, well, something like that. She's really the expert on that. So I just wanted for your information that yes, there are risks to this sort of thing. Our advice is, and I mean what we've given you here is I'm just giving you a very brief overview. But yeah, our advice is that if you decide to do this thing, and you can do it on any subject you like, if you decide to do this thing, group yourselves together, form a nonprofit. Have the nonprofit go to court, not you. And be very precise in what you go in for. Make sure you got them dead bang, because you will absolutely face the full power and majesty of the government. In our case, he's about 5 feet tall. Name's Danny Boyle, King's Counsel. But he has the full resources of the government of Nova Scotia behind him. It won't help him, but he has them. And the reason it won't help him, because we went in so narrow and so concise that he has no argument to make. Section 53(2)(a) of the Nova Scotia Health Act states that the Chief Medical Officer of Health may institute a voluntary immunization program in the province of Nova Scotia or any part of the province. We say that is not what he did, obviously. And therefore he acted ultra vires, and we also say he acted in bad faith. Because here's an interesting thing. Now, when I was in the military, I enjoyed what was called limited liability protection, which means if I'm trolling down the road in my big army truck and you're out there in your Honda and I run you over, as long as I am not speeding, as long as I am acting within whatever orders I had, it's not me. I didn't run you over, the Crown ran you over. You gotta talk to the Crown, bro. Not me, not me. That is limited liability protection. But the thing is, when I was in the military, and I was told this very precisely, the moment I went beyond my orders, the standing regulations and whatever else, the law of the roads of the land, poof, I'm under the bus. Bye-bye, Bill, under the bus. So this is a tool that can be used against administrators, against legislators. We have asked that the judge declare that not only did he act ultra vires, but that Robert Strang acted in bad faith. Once we get that declaration, about 37 seconds later, we will file a multi-million-dollar lawsuit against Robert Strang as a person. I'm still not done. I'm still not done. I'll tell you what, I'm going to ask you a weird favor, just because I don't really enjoy that stuff. If you are motivated or moved, or what I say connects with you, hold on to that. Hold on to that feeling, and tomorrow morning get up and act. I mean, my ego doesn't need any massaging. For reference, I would reference my good lady wife. She'll sort you out on that quick. Okay. So, as the Citizens Alliance of Nova Scotia, and like Ms. Ibrahim, I would invite you to join. Me, I think it's more useful to have boots on the ground and dollars in the bank. So, what we're doing, judicial review. Am I supposed to update them, or?
I think that's Tara. Well, we can both.
Oh, okay. Yeah. Oh, okay. Well, did you want to do this one?
Yeah.
You want to finish up that part?
Yeah.
Okay.
We can conference. Okay. Well, we can.
Thank you very much.